We'll get things rolling. Welcome, everyone. Thank you for coming to our conversation with Navi Pillay. This is very exciting. Um, Navi was honored and awarded a Lifetime Achievement Award last year at our International Law Weekend 2023, and we're excited to have her here to talk about her life and career. But first, I want to introduce our host and moderator, Milena Sterio, before we kick things off. Milena is the Charles R. Emmerich Jr., Calfee Halter, and Griswold Professor of Law at Cleveland State University College of Law. And she's also the managing director at the Public International Law and Policy Group. She's a leading expert on international law, international criminal law, and human rights. Before joining Cleveland Marshall, Professor Sterio practiced law at Cleary, Gottlieb, Steen and Hamilton in New York City, and served as an adjunct law professor at Cornell, where she received her JD. Professor Sterio is also noted for her editorial role at Law Girls blog and served as a Fulbright Scholar at Baku State University in 2013. So thank you for moderating for us today, Milena.
Thank you so much for the kind introduction, Julia. Now, good morning, good afternoon, good evening to our audience members, wherever you might be. It's truly an immense pleasure for me to moderate this panel today, which will be a conversation with our distinguished guest, Navi Pillay, the recipient of the ABILA Outstanding Contribution to International Law Award just last year. Now, please allow me just a few minutes to briefly introduce Navi Pillay. After that, I will engage in a moderated conversation with her about her career and her achievements in international law. And towards the end of the hour, we may have some time for your questions. If you have any questions, please use the question and answer feature in your Zoom settings and send your question, and I will do my best to work it in towards the end of the conversation. So without further ado, allow me just a few minutes to just provide a few highlights from Navi Pillay's outstanding bio. If I bothered with the entire bio, Navi, we would not get to any of my questions. That would take up the entire hour. So let me just offer some highlights. Navi Pillay is a South African jurist who served as the United Nations High Commissioner for Human Rights from 2008 to 2014. She's of South African origin and was the first non-white woman judge of the High Court of South Africa. She also served as a judge of the International Criminal Court and also judge and president of the International Criminal Tribunal for Rwanda. In April of 2015, she became the 16th commissioner of the International Commission Against the Death Penalty, and she's also one of the 25 leading figures on the Information and Democracy Commission launched by Reporters Without Borders. Navi Pillay is also currently serving as an ad hoc judge of the International Court of Justice in the Gambia versus Myanmar proceedings. And in addition, she's the chair of the UN Independent International Commission of Inquiry on the Occupied Palestinian Territory, president of the International Commission Against the Death Penalty in Madrid, president of the Advisory Council of the International Nuremberg Principles Academy, and the chair of the quasi-judicial inquiry into detention in the Democratic People's Republic of Korea. You are quite busy, so thank you so much for finding an hour to talk to all of us today. Now, my first question has to do with the beginning, if you will. I know you grew up in South Africa, in the apartheid era South Africa, where surely there couldn't have been too many non-white female attorneys around. So how did you decide to go to law school, and did you have any role models when you decided to go to law school?
Oh, thank you. I'm very pleased to meet all of you, and I particularly appreciate this wonderful award given to me by ABILA last year. You know, you begin your life and then you look back 50 years later and think, did I really do all that? So that's the first thing. I wanted to do law even as a child, but I would not have been able to explain the reasons then. And you're quite, Milena, you're quite right that there were no models for us to follow. In fact, we didn't have the newspaper at home, we didn't have the radio, and of course the country didn't have television. because the Afrikaans government was deeply suspicious of television. So I wonder now where I got the information. So clearly it's from listening to the grown-ups. And I understood that we were discriminated by unjust laws. You know, my father was a bus driver, and he would report how the police, traffic police, were abusing him, and he couldn't respond. So firstly, I developed a sense of, I want to know about here, and I want to know what I could do about it. And mainly how I could help my family and friends to live under these laws. So no role model, and you're quite right. There were not many female lawyers. When I was admitted, then I think I was the third non-white woman and the first to open a law practice. I opened the law practice because I had no other choice. I was discriminated on grounds of race, gender, and class. Other lawyers whom I went to for a position said, well, is your father rich? What kind of work will you bring in? And you're a woman. What if you fall pregnant? And we cannot have our white secretary taking instructions from a black attorney. So these were the obstacles. And throughout my life, you know, when you are faced with a brick wall, then you try and do something about it. And that's why I started the practice. And you may want to know what I was thinking, just starting a practice on my own. Some male colleagues thought I was being very presumptuous in thinking that a woman can manage a law firm. So in my mind, I thought, well, what's the worst that could happen? You know, I may have to close shop after 6 months. But when I made the rent for the first month, I thought, all right, I can keep at it. So this was, I don't know if you want to know about the kind of law practice that I went on to.
Yes, absolutely. Tell us about that. Yes, absolutely.
So also remember, we had no exposure to international law. No university taught it, even up to now, very few do. And we were not aware of the United Nations as we grew up. Our teachers were terribly afraid to comment on the laws or apartheid itself, otherwise they would have been fired, and some were. So we had a very insular education, deeply supervised by the state apparatus. And when I started my practice, I was helped by other colleagues, black colleagues. If they had too many criminal cases, they would call me at 5 to 2 to say, can you get to court at 2 and do the case for us? And gradually clients would say, well, why do we have to pay an advocate so much more when we can have you do this? I think that that's a lesson in life. You have a responsibility toward your client. You have to prepare. You have to know the law. We all, you know, have a conscience about these things. I was deeply troubled each time I lost a case and examined my own conduct. So I should tell you that the practice went on for 30 years, and my husband joined me as well. He's the one who was detained under the Terrorism Act and so on. But at the end of 30 years, it was really a bankrupt practice because we were human rights lawyers. I enjoyed the choice I made, but it was a financial struggle.
And then I understand that in the early 80s, you went ahead and went to study at Harvard Law School. So since we have many American audience members here, it's always interesting for us to hear about that. So how did you decide all of a sudden to go study in the United States, and what was that experience like?
And if I may jump in quickly, I'm so sorry. Navi, I think one of your headphones might have shifted, and so we're having a hard time hearing you.
Do I have a minute just to pick it up? It fell.
Okay. Oh, bummer. Thank you.
Yeah. I'm sorry about that, Julia. I should have told you
No, that's perfectly okay. Thank you for picking it up, and I'll back out again, and you can talk about Harvard.
Milena, thank you for that question about Harvard. First, let me say, one of the great influences on my life were some lawyers in the United States. We had the Civil Rights Center that President Kennedy, I think, set up in Washington. There was LEAF, the Women Lawyers Organization in Canada, and they inspired me with their work. With regard to Harvard, I had just completed the one of our trials, and this was the Harry Gawler case, the ANC trial of 12 people who had been sentenced to life imprisonment for political activities. And when I went to see them on Robben Island to explain to them that they had lost the appeal, then they said to me, look, you have to understand that even in the courts, it's a political struggle. And they suggested that I take the court records, go to the United States, and talk to judges there to see whether they would have accepted this kind of evidence that had been taken under torture and under detention and solitary confinement. So they put that idea in me. I saw a little advert that Harvard was offering scholarships for Black South Africans at the instance of the students who demanded that there had been no Black South Africans at Harvard. So I was the third recipient of that scholarship. I went to Harvard, and I must say I was deeply influenced, because when I came back with my master's and wrote an article on women's rights in our newspapers, this was all new to us. We did not quite know about that kind of activism. It was much more a struggle for our liberation. People landed in prison for whatever they said. This was on women's rights that I wrote about. And one advocate said, it's because she's had international experience that she could speak out like this. So Harvard taught me to speak out and to be forthright, to articulate. These are not lessons you learn when you come from an insulated, poor community, poor education, segregated apartheid education, including at our university. The non-white section of Natal University was held in a potato warehouse. That's where I was educated. So with that level of education, it was a wonderful experience, not only to study at Harvard, but mainly to meet with law students and lawyers and activists. And later I saved my money and went back and did the SJD at Harvard.
Must have been quite an amazing experience. Now, let me fast forward a little bit to the 1990s when you were nominated and then appointed to the High Court of South Africa. Now, you famously stated that the first time you entered a judge's chambers was when you entered your own. Tell us a little bit more about this. What was this like, becoming a judge after years of not being allowed into judicial chambers simply because of the color of your skin?
You know, it was much more humiliating for us Black lawyers. And that is, we would walk into a magistrate's office, for instance, and he'd still have his booted feet on his desk. So you were talking to the soles of his feet. You were never asked to sit down. You had to stand up. So really a humiliating experience. And so we never got to enter judges' rooms because there were no non-white judges. They were all white and male. And so it was covered in the media because this was so new that President Nelson Mandela made this appointment. And, you know, he phoned me at home. I didn't know it was him. It was early in the morning. I was in the kitchen. This call comes in and the woman says, hold on for the president. And I thought, oh yeah, the president. This must be my brother playing the fool. But it was President Mandela. Apparently he used to get up at 5 in the morning and start working. And he said to me, congratulations on your appointment. This gives me great joy and I hope it will become permanent soon. I was so struck by that, the trust he placed in me. He didn't say, I'm appointing you the first woman or the first Black woman. I trust you to do your job well, nothing of the sort. It gives him great joy. So you can imagine how much that motivated me. When I entered the court itself, I saw all these rules, and I found that actually amongst the white male judges, they were so divided. There was the Afrikaans-speaking judges and the English-speaking judges, and both groups invited me to join them during the tea break. They were really very professional though when it came to judicial work, and they helped me a lot too. Sorry about that. Let's get somebody to see how to put this on. Apart from that, the judge president pushed a list in front of me and said, you can appoint 2 assessors, you take them from this list. And they were retired white male chief magistrates. And I said, no, do I have the power to select my own? And he said, yes, you can. And this is what I did. I appointed 2 African colleagues of mine, attorneys, to sit with me as assessors. So this was not only the first time for an attorney, because usually the advocates only came from the bar, the advocates. The advocates then held a meeting. They were all, it's a white bar. They held an urgent meeting. Agenda item 1 is Pillay, Pillay's competency. So they took a decision to ask their president to come and monitor me to see how I'm performing. The public took this up in letters to the press to say, well, why didn't you monitor the apartheid era judges? Why are you doing this to her? And when I went into court, my colleagues, the white male judges, were so angry about the notion of judges being monitored. So they were truly supportive of me. I heard that this advocate, senior advocate, did pop into the court, but he never greeted me. I didn't see him. And that was the end of that protest of change that President Mandela initiated.
Wow, another amazing experience. Now, from there, my understanding is you did not stay as a judge on the High Court for very long, because then the next appointment you were asked to serve as a judge at the Rwanda Tribunal, which was a relatively new institution at the time. And my understanding is that you were the only female judge for several years. And then your tenure there, one of the very notable achievements, one of the things that your tenure at that tribunal is known for is your role in the Akayesu case, where rape and sexual violence were recognized for the first time as acts which would constitute genocide. So tell us a little bit more about the next career shift. How did you go from the High Court of South Africa to the Rwanda Tribunal? Maybe it was another early morning call for you or something else. And then what was your experience in Rwanda like?
Well, I said that President Mandela said he hoped that the national appointment would be permanent. Well, he himself then nominated me to the United Nations General Assembly. It was South Africa returning to the UN, being received back as a member. This was Mandela as president. So I was very surprised when I was unanimously elected, particularly by all the African leaders whom we thought were chauvinistic and would want a man. Actually, what happened was I received a call from New York lawyer Jessica Neuwirth, close friend of mine, who helped me write the Akayesu judgment, but who before that came to South Africa from Harvard to serve an internship at my office and got a first-hand sense of how these political trials move. And so she urged me to put my name up for the Rwanda Tribunal, and she said, if you don't, we won't have a woman on the bench. I was very reluctant. We had struggled for so long for democracy in South Africa. I want to participate in the new democracy in my country, maybe continue to serve on the bench. These were my hopes. But when she persuaded me, then I found out that it's for 4 years. And even that shocked me. 4 years, I can't leave my country for 4 years. The thing is that I know in the United States, it's just expected. Everybody gets an outside experience, and they still do, but not there. So it was very strange that I went to the Rwanda tribunal. Each time I came home on holiday, people would see me on the shopping malls and so on and say, why did the government send you so far? Can't you ask them to get you back? So you see, that was so little understanding, including from me. And I was really very timid about serving because I had not done any international law except a few courses at Harvard. But that's it. You are given a task. And Jessica said to me, well, if you don't like it, you can resign after a year. But when I started hearing the testimony of witnesses who had suffered so much, they'd lost their entire families. And I thought, exactly what are you complaining about? That there's no butter, there's no pasteurized milk. We soon got to love this rural place, Arusha, where the court was. But I did begin with a lot of complaints, and people knew who it was that was complaining because there's only one she on that bench. I once complained that the power was fluctuating and the mosquitoes were biting me when I was trying to draft a judgment. I was in tears. So I went through all those normal aches and pains and anxieties on whether I could do the job. And I immediately started preparing myself for the position by attending courses run by the ICRC. And of course, through Jessica, lots of exchanges from academics in the United States. I'm very grateful to most of them who sent us photocopies of judgments because we didn't have computers. We didn't have fax machines. All that was set up later. So I remember those slippery fax machines that only older people will know what that was about. It came out very wet and slippery, and the writing soon disappeared. Well, that's how we got our first case law sent to us by academics and lawyers in the United States. And then you mentioned the Afiesu case. I sat with 2 other judges. The judge from Senegal, Judge Kama, presided, and Judge Aspergen. Judge Kama is late. Judge Aspergen is in Sweden. We're very much in touch. So my 2 colleagues didn't know how to handle all this evidence of sexual violence. They were appalled, couldn't hear it. They preferred to block their ears. And once Judge Kama said, just switch off this video we were watching because he couldn't bear to see anymore. And then when it came to writing the judgment, we had a team, and the head of it, the senior lawyer, he came from Denmark. He said to me, well, just give the woman a sentence or 2 and forget it. And this is the way he thought we should deal with all this evidence that people gave us about horrendous sexual violence and rape, which we found amounted to genocide. And so, as I said, I hired Jessica Newworth, who came up to help me write that judgment. My 2 colleagues left it to me to write the judgment, but when it was completed, they supported me 100% on everything that had been written there. So therefore, it's the position of all 3 judges. I did step in and ask the first questions of witnesses because rape was not charged in the first indictment. It was after we judges indicated that we wished to hear the witness. So here was witness J, for instance, saying that she saw her 6-year-old daughter being raped by 3 men, and she knew the names of the 3 men, and that she herself was raped. The prosecutor then interrupts her to say, we don't want to hear that evidence. We just want you to talk about the killings. So I felt, what is this place but an international court to deliver justice? You know, Melina, I mentioned this because you're a law professor, you would understand that there was some criticism of these attitudes, that we were being activist judges. But I saw my role as rendering justice. We had no right to tell that witness not to talk about the full scale of what was done to her. So after the judges indicated an interest, the prosecutor asked for time, which we gave them to further investigate, and they then found the women witnesses. They were there all the time, of course, but they had to be found. It was not only women witnesses, but men who testified on evidence of gang rape and so on. It was only Tutsi women who were targeted, and therefore it fell under the genocide grouping of an ethnic group being targeted. That's why the world's first judgment ever of rape and sexual violence constituting genocide, and of course the very first judgment that it was a war crime and a crime against humanity. But to do that, you know, it, as you know, as all lawyers, all our listeners know, you know, you don't think of something and put it there. The evidence has to lead you there, and then you have to spell out the criteria and elements of the crime, which had not been spelled out before. The International Criminal Court now has it in their own statute. They benefited from the jurisprudence of the two ad hoc tribunals.
Absolutely. And I do think that the ICC to this day continues to be influenced by the jurisprudence, by the case law developed by the Yugoslavia and the Rwanda tribunals. Now, you mentioned the International Criminal Court, which is an excellent segue to my next question, which has to do, after your experience at the Rwanda tribunal as a judge and as a president, you then went on to serve as a judge at the International Criminal Court. So I wanted to hear a little bit more about that experience, and how did that experience compare to your tenure as judge at the Rwanda tribunal? Obviously very different institutions, but how would you compare the two, and tell us a little bit more about your time in The Hague?
You know, I'd love to do that, but let me indicate that I never applied for any of these positions. So here I am, serving in Rwanda, completing the media judgment that is on freedom of speech and hate speech and so on. Also a very important judgment. I was completing that when I got a call from the president of the Constitutional Court in South Africa, Judge Arthur Chaskalson. And he said that there were nominations called for inside the country for candidates to serve on the International Criminal Court. Of course, you have to go through the election process at the UN once you are nominated by your country. And he said that I had received the most nominations and that he knew my work. He interviewed me briefly. So the regulations that South Africa set, in line with other countries such as the UK, is there has to be this kind of democratic process with lawyers and judges involved in this selection process. But the decision has to be made, the recommendation has to be made by the highest court in the land, that's our Constitutional Court, and they then submitted my name to the president. This time it was President Mbeki, and he appointed me to be the candidate, and I was elected at the United Nations. I mentioned this to say to you, can you imagine how I felt? That my colleagues, the lawyers in South Africa, were watching my work, because you know, you're working really hard in a little corner of Africa and not realizing that people are appreciating the hard work you're doing. So to me, it was the greatest compliment that my peers in South Africa had all nominated me. And that's how I got to the International Criminal Court. And yes, you were right. I was the one of 6 judges. I was the only woman in the first 4 years of the ICTR. Then I became the president, and there were other women joining us. In the ICC, learning from lessons of the ad hoc tribunal, there was a stipulation. There has to be 50% women, or at least a good number. So there we were. I think, I forget the numbers now, I think 8 out of the 16 judges were women, and I was one of them. I was put on to the appeals division because I said, please, I served in trial chambers, which means daily listening to evidence and just not being able to sleep after you've heard that kind of evidence. You'd never forget for life what people experience in conflicts. This still moves me. And I'd like to say to all lawyers, you know, that's it. It's not just knowing the law. You have to have compassion. You have to have a heart. You have to have a conscience when you practice as a lawyer, whether it's a commercial lawyer or a criminal lawyer. Human rights comes in every aspect. So there I was on the appeals chamber, and I would like to mention 2 things that we did there. One was a judgment delivered by the pretrial chamber, which issued an indictment for Lubanga from the DRC, who was the #1 leader, but refused to deny the prosecutor's application for an indictment against the #2, because they reasoned that the words of the Rome Statute says you go after those most responsible. So you just go after #1. So in our appeals chamber, we said, no, you look at the seriousness of the crimes and the involvement of the person. After all, it was never intended that only Hitler should be put on trial in the International Military Tribunal. All the other leaders were as well. So that was our first appeals chamber decision. The second one I'm very pleased about, which was very new to me, which is what is the role of victims and their participation in the court cases. Now, I'm totally unfamiliar with that because the common law practices do not give such a role to victims, but the Rome Statute did. It allowed victims to participate in the proceedings, to have defense counsel represent them. And so the pre-trial chamber, no, it was the trial chamber in that case, ruled that they were not entitled, for instance, to discovery of documents, because they were very wary of defense, the accused defense saying they can't be challenged by 2 parties, the prosecution and the victim. But when we looked at the Rome Statute, we spelled out the scope of the participation of victims, which is they have the right to discovery of all documents. They have a right to cross-examine the witness with the accused, the defendant, as you say in the United States, provided that it's all under supervision by the judges of the chamber. So that's the other thing I'm proud of, because it opened up rights to victims. And now I understand they have a voice, they need to be heard in the court. They're invisible actually in common law court that we are accustomed to. So I hope that good international provision influences national systems to change and provide more scope for participation by victims and families.
Absolutely. And in terms of comparisons between Arusha and The Hague, I would venture to offer that the mosquitoes are probably not as troublesome in The Hague as they are in Arusha. So probably didn't have to deal with that one.
Yeah.
Absolutely.
But since we complain about everything, yeah, it was cold though.
I'm sure it was colder than in
Yeah.
Arusha, for sure.
In Arusha.
Yes. Now, in terms of tribunals, in addition to working at the High Court in South Africa, the Rwanda Tribunal, the ICC, You have also been an ad hoc judge at the International Court of Justice in the Gambia versus Myanmar case. And I should add here that what's also remarkable is that the Gambia selected you as their ad hoc judge, even though you're not a Gambian national, you're a South African national. So yet another position that you clearly did not have to apply for. How would you describe your role and your experience as an ICJ judge compared to your experience at all the different international criminal tribunals?
Very different. Thank you for the question. And I'm currently still an ad hoc judge because that matter is still pending. We're just at the stage of provisional orders that the court has made to Myanmar to protect the Rohingya against genocide, the protection orders. I've been there several times. It was new to me. So clearly that is a court for member states. And for years and years, they address only the interests of member states. And you can get jurisdiction before that court only if you're a member state, either through way of a dispute between two states, which comes before the court, or through the UN General Assembly requesting the court for its advisory opinion, like it has just done now in the matter of Palestine and Israel. So my situation was a dispute between the Gambia and Myanmar on Myanmar's treatment of the Rohingya Muslim community, and it was brought under the Genocide Convention. So the court, even for its provisional orders, has to find plausible indications that genocide is going on in order to give that preliminary ruling, yet making absolutely clear that it is not making up its mind or delivering any decision on genocide, whether genocide has occurred, is occurring. So very interesting to separate those. Really, this is civil law. It's not a criminal court. It doesn't penalize people. It spells out to the members. It interprets all these conventions and treaties. I introduced myself to the then president, the rotating president on the ICJ, and asked him, will I be able to ask a question? Because we're very used to that in the criminal court. That's what I'm used to. And he said, no judges ask any questions. If you have a burning question, you raise it at our meeting before we enter the courtroom. And if the president and the other judges think the question should be asked, then the president will put that question through. So indeed, a very formal atmosphere. However, I think they work really hard now that I'm an insider. They have very many cases, and they are so careful about deliberating and getting each judge's views, reasons, and votes. So that is something new. There is a sense of urgency in the criminal court. We can't do that. There's a defendant waiting for judgment. There are witnesses. It's much more rushed. Here, I like the opportunity of really studying and applying the law. So although the Gambia nominated me and Myanmar nominated a German professor whom I know very well, neither of us are there to take sides. We are professional judges. We interpret the law as impartially as the other judges do. But just one little point, we are called ad hoc judges. And so we're not members of the court. And I heard from previous individuals who had served as ad hoc judges that they really do have a sense of treating ad hoc judges not as judges. So I'm not used to that. I was the judge president of the Rwanda Tribunal. I got totally different treatment. And I loved engaging with them on the law. However, I noticed that when the court is addressed, the lawyers say, Mr. President and members of the court. So sitting there, I feel, I'm being excluded here, I'm ad hoc judge. I thought, should I do something about that, or should I just let it rest? Not too important for me. So just a little thing, how I continue to be aware always for any kind of discrimination.
Absolutely. Now, there's an audience question that I would like to work into the conversation. Now, you mentioned earlier about your role at the Rwanda Tribunal as a, activist judge. Do you think that the future, this is a question from one of our audience members. Do you think that the future of international courts will involve a greater number of activist judges? And obviously here we can talk about the ICC. I don't know how much appetite there is in the international community to create additional ad hoc tribunals, but what do you think about the future? Should judges be, activists? Should they be asking questions? Should they be advocating for, for example, the inclusion of additional charges as would happen in the Akayesu case?
Well, thank you for that question. No, it was absolutely not me saying I'm an activist judge. This was the criticism we received. And when my judgments went on appeal, that was what some defense lawyers raised. They said that I had a bias towards women and was influenced by the women's movement. So that's what I meant. But the activist part did come from, criticism did come from some judges who I suppose were conservative and felt their job is to apply the law as it is. And do we not have enough experience of that under apartheid, where we call them positivists, the judges who applied the immoral laws against us, sentenced people just because the mandatory sentence is there. So it's not activist, it's a human rights perspective that I brought to the court, but still
Absolutely.
behaving as a professional judge. And of course, you do know, I served a stint of 6 years as United Nations High Commissioner for Human Rights before going on to the ICJ. Now that experience educated me on the importance of respect for human rights at all levels, including the courtroom.
And actually, that is an excellent segue once again into my next question, which was about your role as High Commissioner for Human Rights. So how would you describe your role as High Commissioner, and what are some obstacles that this office faces when it comes to the protection of human rights?
When I became High Commissioner for Human Rights, I was entering an entirely new world. I was used to being decisive, delivering judgments, and quickly. Here I had to be an advocate. I had to be diplomatic. I had to listen to member states, since the United Nations is their body, and the Security Council, the General Assembly, the Human Rights Council were all controlled by member states. You had to address them as Your Excellency each time. But it came back to me from ambassadors who sat in the Human Rights Council, who said to me, it's because of your experience as a judge that we value the fact that you listen to us. So apparently that is something that I brought in there. In fact, the ambassador from Israel at the time when I was High Commissioner said to me, we can see that you have brought a balance into the reporting on Israel, because I had invited them to give me their documents, their material, and we'll put it into our report. So say we were reporting on 100 olive trees that just been chopped off, just close to harvesting. That's a resolution. I had to investigate and report it. And Israel traditionally didn't participate in the Human Rights Council. But here in my time with that particular ambassador, we were able to do that. So that is some of my judicial experience. However, it is a very strange place for a judge to be in, because I saw how the UN was divided into silos. There was the Department for Political Affairs, for Development, and Peacekeeping. And they said to me, the human rights belongs to Geneva. And so I slowly made inroads into all of that to make sure they understood the United Nations is a norm-based organization, and all of us have an interest in playing a role in protecting and promoting human rights. So we got that with the Secretary General adopting a rights upfront action. One of the ways in which it manifested was when there was a conflict, such as in Rwanda, such as in Sri Lanka. What the UN did is packed up and left. They rushed out. They picked up the international staff and they rushed out as fast as they could. So we changed that policy to how they could stay and protect. And that was tested in South Sudan, where there was a conflict and a whole lot of refugees were being chased by some faction of the killers. And they all raced toward the compound, the UN compound. Now, what happened in Sri Lanka is that the gates were closed. People were outside and the peacekeeping officers were on this side. In Rwanda, in one of my cases that I heard, the Belgian lieutenant said, yes, he was instructed to leave. So there we see video, he's driving out, the UN vehicle is driving out, Rwandans, the Tutsis in particular, holding on to the vehicles, begging them, please don't leave. You can see the killers have surrounded the school where we are. 4,000 people, Tutsis, were killed after the UN left that day. So with this kind of experience, what happened in South Sudan is they opened the gates. They let the refugees in. To me, that meant they saved 90,000 lives. And in other respects, you know, Secretary General Ban Ki-moon said to me, now I understand you judges, you stick to your principles. It's because I was being requested by the Foreign Minister of Iran to make a visit to Iran. And I know because the High Commissioner for Human Rights does address the question of sanctions. If it affects ordinary people, I would say it's a human rights violation. I think that's why they were very keen on me coming to Iran. And I said to the foreign minister, well, I'm not coming wearing a headscarf because that's not the UN practice or principles. I had heard from the former president of Switzerland, Micheline Camille, that when she went, they wouldn't let her out of the VIP lounge. She went as president. And so her advisors told her to put on the headscarf, and then she was received, for which she was criticized very much by the population of Switzerland. I knew that. And so the foreign minister, you know, went up to the Secretary General Ban Ki-moon, who said to me, why don't you buy a French scarf? And he did this gesture and just put it on here and go there. And I said, no, that's against our principles. We support women's rights. We're against discrimination. And I don't want religion imposed on the High Commissioner, that kind of reasoning, and stuck to my ground. So you don't do that in the UN. If the Secretary General calls you up and says something, I saw that all the other heads, they obeyed, they instantly obeyed. Huge deference to the Secretary General, which I owed to every Secretary General, including Kofi Annan. But there are principles, and that's why you're there. You're there, as judges and lawyers understand perfectly. You have to uphold those principles.
Thank you so much. And actually, so you mentioned the United Nations and the Secretary General, which now leads me to another audience question that came in from our colleague David Donat-Katin, who says that he had the privilege of meeting you the first time back in your Arusha office in 1996.
Oh, wow.
And here's his question. He says, would you be available to be a candidate for the position of UN Secretary General? As we all know, there has never been a woman in that position. So David, I guess, is nominating you for your next job.
Milena, isn't the hottest news right now about aging individuals standing for high office? Yes, so I won't, because I'm 83, and we have to put in a younger, more vigorous, energetic person there, and we have to stop appointing just men in those positions. So I belong to the Global Women Leaders Association, and we starting a campaign on making sure that the next Secretary General is a woman, but not me, because, you know, I'm already stepping down from the International Commission Against the Death Penalty. I told them that, and I'm stepping down from the Nuremberg Principles Academy because I said, you know, I'm aging now. I can see that I'm getting forgetful. So before other people ask me to step down, I should do so. No comment on what's going on in your country right now, of course.
No, you don't seem very forgetful to me, but okay. Now I wanted to, this is a question that has come in from many of our younger audience members. What advice would you give to young attorneys who are at the start of their career in international law? And then second part, and this is my addition, what advice would you give to young women who are at the start of their career in international law?
There are very many obstacles in our way, so many disappointments. Don't let that get you down. I would say in whatever area of law that law students choose to practice, do that. You know, at Harvard, I had many conversations with students. They wanted to do human rights law, but they had to join a big law firm because they had loans to repay. And I saw how much the training they get from these huge law firms doing commercial work is good for them because they get very efficient. They learn to work fast, think quickly. So my advice is none of that experience is wasted in whatever avenues you choose. And you can switch and change. I think you can see in my lifetime, I've done many things. So I didn't stay apart from the law practice. I had no choice there. That was under apartheid. We had no opportunity. So that was 30 years. But after that, I think every 6 years I changed because change is good. And each time you are stronger and wiser and more courageous and always speak up for the principles you stand for. I see so many people just remaining silent when they should speak up. And I said earlier, the practice of law does mean you serve people. People do look up to you because we know the law, we have the expertise. But can we do that with a little bit more heart and compassion? So I just wish all the students well in their career. I get really proud each time I meet young people who are studying law. I'm a firm believer in making place for the younger generation.
Yes,
let me say that, and Milena, there are many opportunities, including in the United Nations, for internship and just to get your foot in the door. Those who do get jobs, you know, they don't leave. The human rights colleagues who work at the United Nations, yes, some of them are there for many years. Their levels are very low. They could easily apply and go elsewhere, but they wouldn't because of their commitment. The same with colleagues working in the International Criminal Court. All the lawyers, they love what they're doing. They're really dedicated. They work very hard. So whatever happens and whatever pressures you have, you cannot lose that. I think it's worth always to talk to someone else about problems that you experience.
Thank you so much. Well, what is definitely different and much better for the newer generations, in particular of female lawyers, is that they do have role models to look up to, including Navi Pillay. So thank you so much for your time. It has been such a pleasure and such an honor speaking with you tonight. To all our audience members, we have been recording this event, and the recording will be available to anybody who is interested, and will be on the ABILA website, and will be available through email as well as other channels. A huge round of virtual applause for Navi Pillay for all of her achievements. Congratulations once again on the ABILA Award, and we look forward to interacting with you again at a future conference, whether it be in person or on Zoom. Thank you so much for your time, and congratulations again.
Thank you very much. It's been a wonderful interview, mainly because of you and your questions. Thank you so much.
Thank you.
And to the team behind you.
Thank you so much. Well, that concludes our evening for tonight, and thank you to all of our attendees. Thanks once again to Navi, and again, we will make this recording widely available. Thank you, everybody.
Thank you. Bye.